Hello, everybody. You're very welcome to our webinar today. What is evening time in Ireland? David Rouse is my name. I'm Multi-Unit Developments Advisor with the Housing Agency in Ireland. We're excited and thrilled to be joined by a panel of expert speakers tonight on apartments in their and condos in their jurisdictions. We will introduce you to our various speakers as we go through the session this evening. I'm just going to briefly share my screen with you now, and we will go through some, if you like, housekeeping and background for our session this evening. As I say, we have a panel of fantastic speakers. Robin Defoe from Canada, Tom Skiba from the US, Enda McGuan from Ireland, Nigel Glenn from the UK, Susan O'Neill from New Zealand, and Dr. Hazel Easthope from Australia. So we will introduce our panelists as we go through. That's myself, as I say, advisor with the housing agency here in Ireland. I'm conscious we have people from all around the globe joining us here tonight. So you're all very welcome, and hope you're staying safe in these challenging times. Our timetable tonight, with the times in Irish Greenwich Mean Time, if you like, we will have a short poll in a couple of moments while I'm doing some housekeeping. We will go to the panelist contributions after that. We will have a short poll midway through the panelist contributions, and we'll have a roundtable and some Q&A at the end of the session, and we'll wrap up and close within about an hour and a half, all going to plan. In terms of housekeeping, we would ask you to keep your questions in the Q&A function on Zoom, with which you'll all be familiar at this stage. My colleagues Sarah Kennedy and Tara Doyle are very kindly in the background helping me on the technical side. So Tara and Sarah will guide us around that. If there are any technical problems, please input them into the chat function, and we'll reserve the Q&A function for questions on the subject matter tonight. Be aware, please, that the event is being recorded for future use. We will send copies of the slides and indeed a link to the recording later on. But if you have any other questions, feel free to contact us at the Housing Agency at the address you see on your screen. A little bit about the Housing Agency in Ireland. We are under the auspices of the Irish Department of Housing, Local Government and Heritage. Our offices are on Merrion Square, which is in central downtown Dublin, but I haven't seen the inside of the office since March. So like a lot of you are working from home in the current environment. We work with the department, with local authorities in Ireland, with approved housing bodies and housing associations and other stakeholders in the housing sector on our website. For those of you outside of Ireland, that's the headquarters of our parent department, the Department of Housing, the Custom House, which comes from the early Georgian period in Ireland. So certainly a piece of historical architecture, if you like, that may be of interest to you. While other people are joining us and logging in, what I might do is run a short poll, which will essentially ask you some questions about, ask a question about the sector we're in. So in your view, which of the following is the most significant issue facing the apartment and condo sector? So some of you may be on different web browsers, and you may not be able to see this, but most of you should be able to. I can see lots of people voting, and lots of these issues are common to the jurisdictions to which we are in contact with tonight. So what are the main challenges? The main challenge: collecting service charges or management fees? Is it recruiting board directors or volunteer committee members for the boards? Is it providing for long-term building investment or sinking funds? And these are issues I know our panelists are going to address in their contributions. Is it meeting the green agenda? So waste, recycling, waste management, energy saving, and so on. Or is it the issue of building defects and construction difficulties, or short-term letting? So please let us know. I can see lots of you have voted, and thank you very much for letting us know your views. For the avoidance of doubt, this is an anonymous poll, so we're not able to link up the replies with your particular communication or with your email address. So please do feel free to give us your views on that. So I'll end the polling shortly. I can see that about nearly 80% of you have participated in that poll, which is a pretty good turnout rate. And I can see that providing for long-term building investment and sinking fund is the far out or the by all accounts the leader in that particular survey. So I'll end the poll and I should be able to share the results with you now. So hopefully you can see there, 37% of you felt that providing for long-term building investment and sinking fund was the most significant issue facing the sector, with an even split for the second place on meeting the green agenda and building defects, and collecting service charges was the third place, if you like, on 11%. So thank you very much for participating in that poll, and I'll close that. I'll close that off now, and I'll just share my screen again very briefly with you to go through some last administration in terms of our session. So really, the session tonight is about tonight with us, indeed, in the afternoon with those in North America, and indeed we're in tomorrow morning, if you like, for the people in the Southern Hemisphere. So the linkages, if you like, and why we have expert speakers from the countries we have, are really the linkages and the connections are rooted in the common law nature of the legal system in each of the countries. The similarity in property structures broadly similar in all countries in terms of holding legal title in multi-unit developments or condos or strata or apartments, whatever term you wish to use. In all countries, we know that there's a trend towards urbanization, and the challenges that are common, as we've just seen in our survey, are worth exploration in all of the jurisdictions that are with us tonight. And what we hope to deliver to you from our expert speakers and from our interaction and our Q&A, and please do input your questions. What we hope to deliver is some insights, some lessons, some shared learnings. So certainly there are aspects of apartment management that we in Ireland are, I suppose, less developed on and less mature on, and we can certainly take learnings from our cousins, if you like, in our countries that are with us tonight. And equally, we hope we can share some insights in the other direction, for want of a better term. So you're not here to hear from me. I will shortly move to Hazel Easthope, but before I do, three short pieces of news for those of you in the Irish sector, in the apartments and multi-unit development sector. Many of you will know that the Property Services Regulator issued a new statutory instrument with minimum standards for property management agents. So that has effect from the 30th of November 2020, and it's available on the PSRA's website. The next point is we will shortly be issuing some guidance information for management companies around engaging a property management agent. So that is that particular guide is due out shortly. And the third quick point is to note that the company's registration office is launching its new system tomorrow. So the new core portal for filing your annual returns goes live tomorrow, the 16th of December. So watch out for that and talk to your company secretary. But as I say, you're not here to listen to me. You're here to listen to our fantastic panel, and delighted as we are to have with us, first off, Dr. Hazel Easthope, who is Associate Professor in the University of New South Wales. And Hazel, I think it's not unfair to say, is regarded as a world expert in the apartment and strata and condo sector. And many of you will be familiar with Hazel's book, The Policies and Practices of Apartment Living. So we're thrilled to have Hazel with us, and we're very much looking forward to Hazel's insights. So with that, I will hand over to Hazel, and Hazel, the floor is yours. Thank you very much.
Thanks very much. Okay, good morning, good evening. Lovely to be here. I'm going to talk to you about what I think are some of the interesting developments in Australia at the moment in relation to the strata sector, which is what we call condominium here. First, just a bit of background so that you understand what I'm talking about. When I say strata, I mean condominium, and when I say scheme, I mean development or complex. We call them strata schemes, condominium complexes or condominium developments. But I'll try and use condominium from now on, but if I slip up, you'll know what I'm talking about. So we've got about just over 340,000 developments with around 3 million lots, which is what we call units, around the country. And the strata sector has been growing very rapidly, especially along the eastern states of New South Wales, Victoria and Queensland. And you can see that in that graph to the right, that almost half of all developments have been registered just in the last 20 years. It's quite interesting. In Australia, we have a very high proportion of renters in our condominium developments, at almost half of all residents. And the reason for that is that we have very few alternatives to renting an apartment in this country. We've got very small public housing sector. It's only about 5% of the housing stock. And we have a fledgling purpose-built rental market, which I'll talk about a little bit later. And what that means is that whether you're wealthy or poor, a renter or an owner, if you live in an apartment in Australia, it's most likely that you live in a condominium. You can see from the demographics here, about 65% of residents are under 39, a third lone persons and another quarter couples, but actually families with children make up a significant proportion of our apartment residents, about 1 in 5 households. Just briefly on the legislative context, we have different legislation in each state and territory in the country, but actually they're broadly similar and they're all quite prescriptive pieces of legislation. One of the major areas of difference is around whether there's separate pieces of legislation for vertical and horizontal developments. So separate for common interest developments, houses in master planned estates, and condominium apartment developments. So for New South Wales, for example, there are separate pieces of legislation, while in Queensland they fall under the same legislation. Regulation sits mostly at the state and territory level, but the municipal government regulates planning controls like zoning and building safety like fire safety compliance, and is also responsible for infrastructure provision. The most significant recent changes to the legislation around the country, in my view, have been the introduction of legislation in some states and territories to enable collective sales with less than unanimous consent. And again, I'll talk about that briefly later. So I want to concentrate on what I see as some interesting issues in the strata sector in Australia at the moment. I'm going to divide them up into the beginning, the middle and the end. So the beginning, building defects are a systemic problem in the sector and have been for some time. But the most common types of defects in Australia are waterproofing, which includes internal water membrane failure and water ingress from outside of the building in. The reasons for that are complex, but they're at least partly a result of withdrawal of government from regulation space over an extended period. There's been a few recent high-profile cases that have required evacuations of buildings, and I've got a couple of pictures of those cases here, which have really put defects on the political agenda here in the last couple of years. But as I say, it's not a new issue, but it is now a political issue and a media issue. The result of these high-profile cases was that in my state, New South Wales, we've hired a building commissioner who is responsible for addressing this issue, and there's a reform process underway. That reform process is mostly based on the front end, so building better buildings, and less attention has been given so far to what I call the back end, or improving the system for defects rectification and dealing with legacy building issues, which hopefully will come in time. So there are major issues regarding fragmentation in the system, which are contributing to this. So there's fragmentation in the construction industry, so issues with the design and construct model of development if it's not well planned and managed, and multiple layers of subcontracting, fragmentation in the regulatory environment, which is making regulation and oversight complex, fragmentation of data sources in terms of being able to collect information at the end of the procurement chain, which can be very difficult. And also, of course, fragmentation in responsibility and management of the defects rectification process, with a lot of people being involved and responsible for aspects of that. Another interesting development at the front end is build to rent. So as I said before, we don't have a well-established rental sector or purpose-built rental sector in Australia, but we're seeing moves in that direction. Build to rent's getting up increasing interest amongst developers, partly because it's a good risk diversification strategy. When the economy goes down, rents tend to remain a stable income source. So the picture on the slide here is Live Indigo, which is one of our large developers, Mirvac's first build to rent development. And it's part of a broader development called the Pavilions. Live Indigo is 315 rental buildings, purpose built, and there are 696 apartments across the whole development. Rents in Live Indigo are about 30% above the median rental price for the suburb, but they've been incredibly popular because they're providing a service that hasn't been available before in the market. The government's supportive of this move towards build to rent and has cut land tax, 50% discount on developments of over 50 units over 20 years to promote the sector. And their stated reason is both to increase certainty for renters and to boost construction of residential building. And there's also quite a bit of interest in this model in collaboration with community housing providers to provide a more affordable version of it. So now onto the middle. How do we make decisions here in Australia? Well, technically decisions are made by owners' corporations, who are made up of all of the owners in the building. But in reality, a lot of those decisions are delegated to a strata committee or a board. And that board normally relies on the advice of the strata manager. Although legally the manager shouldn't be making decisions, just providing information. In terms of volunteerism on committees, I think that differs between buildings, but also between areas and different socio-demographics. In terms of strata management industry, I'm seeing an increased specialisation and professionalisation of strata managers. For example, some companies are only taking on small schemes or only mixed-use schemes or only schemes in particular locations. And some individual strata managers are specialising, for example, focusing only on complex developments with multiple layers of management. But then there are still plenty of managers and companies who are taking on all sorts, and manager workloads are incredibly high in general. We're also seeing a lot of movement of managers between companies, and there's a lot of demand for highly skilled and experienced managers. So impacts of COVID-19, we've been incredibly lucky in Australia not to have had a high infection rate here, but the impacts of COVID-19 have been felt in the economy and the housing market. And in particular, it's had a huge impact on short-term rental and on commercial rental. And that's had the impact on short-term rental has also had flow-on impacts on the private rental sector, as have job losses experienced by many tenants. So what that's meant is that owners of commercial lots have been unable to pay levies and have had to renegotiate payment plans. It's made rentals cheaper in inner city locations because of the reduction of units on short-term lets. But sea and tree change locations are getting more expensive because people are wanting to work from home in those locations. And there's been a lot of movement in tenants in and out of units, reflecting both job losses and changing rents. So the end, we're seeing some interesting developments around what to do with condominiums as they get old here. And we're seeing two things. The first is sales of whole buildings and sometimes buildings in a line, so next to each other, to developers for the purposes of demolition and rebuilding at much higher densities. And we're also seeing resident-led upgrades of whole buildings without demolition. So collective sales, including collective sales of multiple condominiums next to each other, are occurring, especially in Sydney. The picture here is one that occurred recently, and this is a series of multiple condominium developments that sold together. This picture is actually taken from a real estate site when they were advertised for sale. And a lot of these are happening in suburban areas. We've got a lot of apartment blocks that we call walk-ups, which are often 3 to 4 stories near train stations, which are ripe for this type of redevelopment. The other thing we're seeing is upgrades to existing buildings and substantial upgrades, and these tend to be triggered by a large mandatory expense like failing fire safety compliance. And at the moment, these are happening in high value coastal areas. But I expect that we'll see them spread into other markets as well. So to summarise, we're seeing a maturing of the strata sector. We're dealing with a lot of legacy issues around defects, poor management and maintenance, older buildings and land fragmentation. And we're also navigating changes in the profiles of purchasers and residents, and as a result of housing market pressures and changing housing markets. So that's it from me, and I look forward to hearing from the other speakers. Thank you.
Thank you very much indeed, Hazel. I will just ask you to stop sharing, and we can, perhaps I can do it. Excellent. Thank you very much indeed, Hazel. So lots going on, and lots of significant issues in the Australian strata sector. Conscious equally that a number of the countries with us are obviously fragmented in terms of the different legal systems in Australia and in Canada on the provincial basis, and equally obviously in the US where Tom is, and there are nuances within the jurisdictions, and perhaps we can touch on those as we go through. But up next, we are delighted and indeed honoured to have with us Robin Defoe, who's the Chief Executive Officer and Registrar of the Condominium Authority of Ontario. And I know Robin has a very, very busy schedule, so we're very grateful to Robin and indeed her team and her colleagues, Emile and Quinn, for their support in being with us here this evening. So Robin, I will hand over to you. The floor is yours. I'll stop sharing and say over to you. Thank you very much, Robin.
Thank you very much, David. And there we are. Slides are up. I'm just going to say good afternoon from Toronto, Canada. It's a pleasure to be here and to have an opportunity to talk to you about the condominium sector in Ontario, Canada, and how the CAO fits and supports condo living here. I'm going to start with some demographics and the legislative framework for the condo sector. Like other jurisdictions, we just heard from Hazel, we also have seen a rapid and continual rise in condominium development to support population growth and urban density. We sit at about 12,000 condo corporations that include approximately 907,000 condo units, and that's almost 160% increase since 1998 when the original Condominium Act was first passed. We have more than 1.6 million people who live in condos in Ontario, which represents about 11% of our 14.6 million population. In terms of the legislative framework, with the significant growth of condominiums, the Government of Ontario conducted a consultation process in 2012 that resulted in amendments to the Condominium Act. The recommendations included more and better information for condo owners, mandatory training for condo board directors to provide them with some foundational skills for those volunteers, a faster, more accessible and cost-effective dispute resolution service, and condo manager education and licensing. And to address these, the government passed the Protecting Condominium Owners Act 2015, which introduced amendments to the Condo Act and created two separate organizations here with distinct but complementary mandates to protect owners and consumers, and that's ourselves, the Condominium Authority of Ontario, or the CAO as I'll refer to us, as well as the Condominium Management Regulatory Authority of Ontario that's responsible for regulating condo managers here. And both organizations launched in 2017. And I'll just say that we are focused entirely on condominiums. There's an entirely different and separate legislative framework for apartment living in Ontario. So to give you a sense of the CAO, we are an administrative authority created under statute. We're a not-for-profit corporation, independent from the government. We're governed by a 7-member board who come with a range of expertise. Our mandate is set out in the Condominium Act and associated regulations, and we're accountable to the Ministry of Government and Consumer Services through an administrative agreement. And we are funded by condo owners as part of their common expenses fees, which are remitted to the CAO through corporation returns each year. So as I said, I wanted to talk a little bit about the role of the CAO. in the condo sector. We're a new organization, as I pointed out. We launched in 2017. And when we set out to build our initial legislated services, we recognized that in order to be cost effective and reach all condo owners across our vast province, we had to move to a fully digital service delivery model in order to achieve these goals, so that we could provide a fast, accessible, and affordable service to owners and directors anywhere in the province, any time of the day or night. So you'll see here our suite of online services fall generally into two broad categories that are both integrated and aligned. Consumer protection, where we provide information to prospective purchasers, owners, and directors of condos. Mandatory condo director training. We've trained over 35,000 condo directors to date, and they have to, after 6 months of appointment or election, every director has to be trained in the province or take this training. We have a condo returns filing system that collects key information from each condo corporation annually, and we have a system, a public registry, of presenting that information to owners and the public through what we call the condo returns. We have a delegated responsibility for the forms of the Condo Act, or most of them, and this year we also were mandated to launch a new residential condominium buyer's guide in partnership with the Ministry of Government and Consumer Services. The other part of our service is the issues and dispute resolution piece. We provide information, tools, and templates, and importantly, an integrated guided steps to common issues and a fully online tribunal dedicated to resolving disputes. And all of these services, of course, are underpinned by an important information services team who answer a myriad of inquiries from owners and directors and other members of the condo sector. They manage the cases through the tribunal, and they provide policy and program expertise. So just touching on I'm going to focus today on our integrated issues and dispute resolution service. I know all of you here, it's to be expected that living in close proximity can lead to issues between owners and their condo corporation. And our goal at CAO is to help resolve those issues as early as possible, but before they escalate to disputes, with the goal of maximizing enjoyment of where they live in their condos. So you can see here the 13 common issues that are part of our guided steps. And those highlighted in yellow on the list here are the ones that so far have been prescribed by regulation by the government to be heard by our Condominium Authority Tribunal, also known as the CAT. So these current cases, the CAT's jurisdiction, you'll see condo records, pets and animals, parking and storage, vehicles, as well as indemnification and compliance with settlement agreements issued by the CAT. So the guided steps, I'll just give you a visual here to show you the steps that we guide users through. We help them with some background about the particular issue, the common ones that we hear about. What are the legal considerations? What are some potential solutions to help the users potentially resolve the issue themselves? And where should they go if the issue can't be resolved? And I just touched on those that can come to the CAT, and where the dispute type does not have jurisdiction with the CAT, we guide them to other dispute resolution mechanisms. So the Condominium Authority Tribunal is our flagship and most innovative service. The CAT's online dispute resolution service, known as the CAT ODR, which I'm proud to say is Canada's first fully online 3-stage tribunal system, provides a low-cost means for condo owners and directors to resolve disputes. And the tribunal itself, the system, guides the users through the 3 stages you see here to help them understand the process and navigate some of the legal considerations. So stage 1 is self-guided negotiation for the parties, where no one from the CAT is involved. If the issue cannot be resolved, the parties move to stage 2, mediation, where a CAT member will join and try to help the parties mediate. And if the case is still unresolved, the parties go to stage 3, adjudication, where a CAT member will hear the case and issue a legally binding decision. So I recognize that this is a busy slide with lots of numbers. I won't address them individually, but what's important to highlight here is the directional importance of the data. So these data relate to records, issues, and disputes, which was the first area of dispute that the tribunal could hear starting in 2017. And on the left in the dark blue bars, you see the page views to the guided steps to common issues for records that I just highlighted. And on the right side, the light blue bars are the records cases that have gone to the tribunal. You can see the numbers decline dramatically from left to right. On the far left, the tallest blue bar, you can see that there have been over 21,000 views to step 1 of the records issues webpage. And on the far right, the shortest light blue bar shows only 78 cases have gone all the way to the final stage 3 adjudication at the tribunal. So this is a strong indication that the number of, based on the number of times that step 1 of the guided steps was accessed by someone with a records issue compared to the number of disputes that were actually ultimately filed with the tribunal and went all the way to stage 3. They provide an indication, we feel, of the benefits of early information and efforts to support the resolution of issues at the early stages. I want to emphasize that a key element of this integrated issues and dispute resolution service is the binding decisions issued by a CAT member at stage 3. What we've witnessed in Ontario is that when a particular issue has been decided by the CAT, providing a binding order, that it provides clarity on the issue at dispute for other owners and corporations and drives to resolution of similar issues and fact scenarios without the need to go to the tribunal. So our goal, which seems to be working, is to empower owners and board directors to understand the issues, their rights, and their legal obligations so they can settle these disputes and best enjoy where they live. So moving on to the pandemic, which, as Hazel said, created new challenges for organizations around the world. And in Ontario, there was no exception. Also some of the issues that Hazel highlighted, but at the local level, we, as a support to condo corporations and owners, saw 3 main challenges arising at the outset of the pandemic: how to conduct business and meet the legal requirements, how to navigate the new and evolving health and safety measures, and how to support owners, many of whom were anxious about living in close proximity during a difficult and unprecedented time. So a key issue, of course, for the corporations was how to conduct owners' meetings while meeting their legislated obligations, particularly for annual general meetings. Those have to be held within periods of time under the Act. Now, the government of Ontario made it possible for corporations to move to electronic meetings and voting through temporary amendments to the Condo Act that suspended the requirement for the corporations to pass an electronic bylaw. But even without the bylaw in place, implementation of electronic meetings and voting and navigating the legislative and regulatory framework was no easy task. So to assist, the CAO provided several materials, including a detailed guide that clarified what the government's temporary provisions meant, steps for the corporations to take to conduct these meetings, including how to serve notices, how the owners could cast their votes and count towards quorum, the implications for advanced voting, et cetera, et cetera. And what we heard anecdotally is that corporations have been successful in moving to electronic meetings and voting, and they have been well received by condo owners with increased participation in these important shared ownership matters. We need to validate what we're hearing, of course, with data, but this could be a positive outcome that might carry forward after the pandemic and improve engagement of condo owners at the local level. And so we're going to help with that by developing materials on how to pass an electronic voting and meetings bylaw. And I'll end with some data because the CAO prides itself on being evidence-driven. We recently conducted a survey to see how condo corporations were faring in the pandemic and whether our materials were helpful. We're pleased to see that over 4,600 respondents to the survey who reviewed the materials rated them as helpful, those are the blue bars, or very helpful, those are the yellow bars, or very helpful, the blue bars. And so the satisfaction rating was between 75 to 82% across these resources. The CAO is a new and relatively unique organization, both in its services and its digital offerings. In its short time, based on qualitative and quantitative feedback, the CAO seems to be achieving its legislative mandate effectively and is becoming an integral part of the condo sector here. And of course, we're eager to continue this work to support condominium living in Ontario. Thank you very much.
Thank you very much indeed, Robin. Fantastic insight into the legislative and regulatory framework in Ontario. And we can see, I suspect, how rigorous and robust your system is in such a short period of time. So thank you very much indeed for your insights, and I know there'll be threads on which others draw in their presentations. And moving on to our next speaker, who is Enda McGuan, who is representing Ireland tonight. We're very grateful for Enda's time. Enda is from the Society of Chartered Surveyors Ireland, from whom many of the management agents in our apartments and multi-unit developments are drawn. So we're very grateful for Enda and his time tonight, and we will hand over to Enda. The floor, Enda, is yours. Thank you very much indeed.
Thanks, David. I just get myself. And first off, let me just thanks to the Housing Agency for organising what is a good event. To everyone attending, I'm not sure whether I say good evening, good morning, or good afternoon. I'm not sure, but I'll say all three. And look, it's great to see so many people here tonight. What I'm hoping to do over the course of the next couple of minutes is just to give an overview of the Irish sector, particularly as it pertains to regulation. And specifically, I suppose I'll focus in on apartments, even though the regulation we currently operate in would also cover houses as well. But I'll focus on apartments for tonight. This is much like the other speakers. What I'll be endeavouring to do is try and do some demographics and try and put things into context. From my own perspective, obviously, I'm involved with Chartered Surveyors. I'm also I'm a managing director of a business. We manage, over 90 owner management companies. As a role, we provide services to those, and I'm involved in education as well. So I suppose it's trying to give a rounded perspective of how regulation has impacted here in Ireland over the last number of years. I suppose from an apartment perspective, I suppose the other factor just worth noting is we're at an early stage in development of apartments, as you'll see from some of the figures here. As it was put to me a number of years ago by somebody who's moved to Ireland and working in the property sector, they put it quite aptly that traditionally the Irish view of an Irish apartment was a 3-bed semi-detached house on stilts. So that's something we're beginning to overcome as our cities densify and as we move forward. So I suppose, look, moving firstly to the figures, and I use these slides quite a bit in presentations because they illustrate our population and our ownership figures, but they also show a time impact on regulation. So I suppose up here to the top left it's a busy slide, but it's our owner-occupier rate. And again, much like many of the other countries involved, our owner-occupier rates have grown up to the 1990s and then started to decline. I suppose why I'm indicating here and specifically is 2011, because that's when the first time our owner-occupier rate dipped below the EU average. I suppose it was 3 years after 2008 recession. And I suppose it's very important from an Irish context to reflect back on that, because the reality is our experience of that recession was very much a property-driven crash. And in 2011, this was the year that we saw the introduction of the Property Services Regulator Act, which set out the role of the regulator in the provision of training or supervision of property service providers like the business I run, which provide letting services, property management services, and sales services. So they were all governed by that act in 2011. Similarly, at that point in time, we saw the introduction of the Multi-Unit Development Act, which governed how owner-manager companies should operate, the financial parameters, and how managing agents should support them in doing their day-to-day work of maintaining buildings and housing estates. Interestingly, again, keeping on the 2011 theme underneath, this illustrates a point in time whereby the number of people in Irish households had been declining. Again, smaller family sizes. It had been going on for 10, 20 years. In 2011, we saw the first time we saw that figure go up. And what that illustrates is that the impact again of the 2008 recession, we had stopped building houses, and that, as in many cities in Western Europe, we had children living at home for longer and unable to move out to the desired apartments that they wanted to move out to as a first starter destination. And I suppose that's something that a lot of our construction industry has been looking to address over the last number of years. And lastly, obviously, to the right here is our population demographics. Ireland has a population, again, in keeping with many Western European countries, which is getting older. However, home ownership, predominantly in houses, is concentrated in the top tier, the older population, whereas the middle tier here is predominantly where our apartment livers are made up from. So I suppose moving on, and these figures are based from two very good reports, again, published by the Housing Agency last year. One was the Sustainable Apartment Living in Ireland report, and the other was the Apartment Living in Ireland. It was almost a temperature check of how people viewed their owner-manager company experience. And again, as I said, 7% thereof of the Irish population live in apartments. We're much more lower than the EU average and our nearest neighbours in the UK. Within that framework, it was interesting to hear in Australia, whereas 50% of that cohort would be rented. In Ireland, it's 80%, with 60% private and 20% social housing tenancies in those apartments. The key thing, I suppose, for a build to rent perspective is that as the National Development Plan in Ireland envisages that over the next 20 years, our cities are going to go by figures of 20 to 30%. And they are targeting density in those cities, and that is going to be delivered through the growth in apartment living, and something that the regulator is looking to control and to manage as we move in that direction. I suppose down here, from my own perspective as somebody who's working in the sector, it's interesting to see that 73% of people in that survey indicate that their owner management company is well run, and they think that service charges are good value for money. And I think maybe that talks to the impact of the regulator and the education process that's been embarked on by supporting agencies like the Housing Agency over the last number of years, that people are more aware of their rights and more aware of what they should be receiving. I suppose moving forward, in terms of establishing a regulator in Ireland, this slide tries to illustrate what the ideal scenario would be, were you starting from a clean slate. So obviously we have our two core pieces of legislation, as I say, the one which establishes the property services regulator at the top. We have the regulator in their role. They are providing and supervising the property service providers who support the owner management companies and then who protect the property. And it's a nice straight line process, and it's, with the property owner protected by all these various layers. Obviously, unfortunately, as with any introduction of a regulatory environment, we didn't start from a clean slate. So this slide, which is quite busy, but it helps to illustrate the actual environment that we operate in. So your owner management company, your regulator, your legal legislation, and the property service provider are all interacting with a variety of other elements. So from a legal perspective, obviously you have building regulations. And again, it was interesting to hear from an Australian perspective that it was highlighted a potential withdrawal from regulation. Whereas here we have increased regulation, we have building certification process to help try and address the building defects issue, which arose over the last 10 or 15 years. From a regulatory perspective, the regulator works with the likes of the Housing Agency, government departments, the Companies Office, which was mentioned at the start by Dave in his presentation, and even the Tenancies Board. So I suppose the point of this slide is to illustrate how busy the environment is, how many interactions take place, and how much influence is on the owner management company and the owners themselves. I suppose to simplify it a little bit, this is the basic structure we would operate here under Ireland. So again, you have the property owners with an elected board of directors, similar to the stratas as highlighted in Australia. The regulator's role is very much to protect the consumer, which is the property owners and the board of directors. It's also responsible for ensuring that the managing agent is licensed and has trained staff. The managing agent then, the property service provider, so reports into that board of directors, and it procures services to maintain that development or that building. So be that from simple things like landscaping and gardening to insurance, but obviously more detailed services like solicitors or even specialist service providers, such as in the area of building defects. And sitting out here to touch back on David's theme at the start of the financial side is the role of the auditor. And I know it's something that we may discuss later on, but it's the auditor is independently appointed, and their role is to review the sets of accounts produced by the managing agent for the board to ensure that the company is trading and operating in compliance with financial best practice. So I suppose in terms of ongoing issues and current issues here in Ireland, we see, as in Australia, and the increase in the role of cost rental and build to rent. I suppose the most significant aspect of this transition is a change in the Irish property market, particularly in apartment living, from building apartments to sell them to building to live in them from the longer term. And I suppose we're moving to a situation whereby the whole idea of whole life cycle costing is becoming much more important in terms of, and it's hopefully talking to the area of sinking funds and the area of how we provide for these developments out into the future. From a sustainability perspective, Ireland obviously has recently embarked on a 500 million euro government-driven policy to try and upgrade the quality of our homes, both from an insulation perspective to how we utilise heat and energy. Building defects are an ongoing issue. We have at this moment in time a government body a government committee looking at the whole area of building defects, with a view to first off establishing what the nature of them and the extent of the impact of building defects is across the country, but B, potentially looking at addressing the thorny issue of how you fund and finance those defects, particularly when you're concerning something which is as important as people's homes. And I suppose the last 3 points then touch on, I suppose, 3 key areas which have developed more recently, I suppose, as a result of COVID and realizations that have been hammered home to us all. Obviously, for the last 9 months, we've seen more and more people working from home, and in many instances, schooling from home as well. So home and the apartment has become somewhere not just that you go to sleep, but it might be where you work and actually live. And that, I suppose, has given a heightened awareness of the broader environment. What's the nature of the communal areas? What's the area of the recreation space? I suppose it has also drawn attention to things like community building and the role of the management company in helping to develop a sense of community among, something, as I highlighted early on, where 80% of the occupants are renters in an apartment block. How do you develop that community, and how do people support each other in times of difficulties? And I suppose the other point that talks to, and it goes back to the population demographics I illustrated early on, is aging in place. And how do we build apartments and communities which allow people to sustain situ for as long as they desire? I suppose the last point then to touch on before I conclude is something which is very prevalent and very current here at the moment, in the UK and Ireland. That building to the right is Grenfell, which is a building which burnt down 2 years ago in London. And I suppose there are ongoing inquiries and investigations to that, but they're of, I suppose for me, they're of great relevance to the sector as it is, I suppose, because they talk about the issues in Grenfell, some of them related to the thread of good quality information that I've quoted here. I suppose a link between design, construction, occupation and maintenance. And I suppose for me, we now need to refocus ourselves on how we ensure that we provide environments for people to live in which are safe, but I suppose are also operations led. I know somebody previously has talked about architect led design. Our focus, and my preferred focus, is on operations led design, that we build places as to how people want to use them and to live in them. So with that, I'll hand it back to yourself, David, and thank you.
Enda, thank you very much indeed for your insights into the Irish apartment sector. Very much appreciated, as we can see lots of similar threads and issues coming through all of our guest jurisdictions, if you like. Before we hand over to Hazel O'Neill, I'm going to run a second poll, which really is rather more a survey than a poll, just to ascertain where you are, where our attendees are tonight. This is an anonymous poll again, so if you kindly feel free to fill it out, and we'll just use that for our own reporting purposes, if you like. As I say, it is anonymous, so I can see about 80% of you have voted. So we'd be grateful if you could just let us know where you are. And as I say, this is anonymous. There may be some of you on different browsers who may not all be able to participate in the poll, so we apologize for that, but hopefully most of you can, and I think that's the case. So we have about 80%. So if any last few takers want to populate the poll for us, we'd be very grateful if you'd let us know where you are. So thank you very much indeed for that. So I'll close that and appreciate your assistance. There's a few more of you still voting, so I'll give you a last opportunity. We'll have run it for a minute there, so that's great. Thank you indeed for that, and we'll share that with our panelists later on. So moving on to our next speaker, and we're moving back again to the Southern Hemisphere, if you like. We are delighted to have with us Hazel. Susan O'Neill, and Susan is from the Department of the Ministry of Housing and Urban Development in New Zealand, and Susan is principal policy advisor with that department. Again, we're very grateful to Susan for her time on a Wednesday morning with Susan, and we can hand over to Susan now. Susan, kia ora, and thank you very much indeed for being with us today.
Kia ora, David. Thank you for that introduction. Hello, everyone. So I'm going to start with just sharing some quick facts on the unit titles sector in New Zealand and its role in the housing system. Then I'll discuss some basic features of the current legislation. So this is going to be quite legislation focused because that's where my focus is. And then I'm going to cover some of the issues that were raised in a recent review of the legislation and talk about where that review is at. So what are unit titles? In New Zealand, we talk about unit titles, so I'm sorry, I'm going to carry on talking about them in that way. So in other countries, they're known as strata or condominiums. So unit titles are the form of land ownership where there's common property to manage. The unit owner owns a unit, which is a defined part of the building, and then they share ownership of the common property with all the other unit owners. So some quick facts to start you off. The Unit Titles Act was introduced in New Zealand in 1972, but we had a major change in 2010. So the year after it was introduced, there were 5 unit title developments created in New Zealand, so not too many. Last year, there were over 5,400 created. So that gives you a bit of a sense of where we've moved to. New Zealand is increasingly building multi-unit homes. So in the year, and that 2020 figure goes to August, so it's the year to August, multi-unit properties were 40% of building consents. That does include some homes which are not unit titles, but it gives a sense of scale. Now, as you can see from these 2 figures here, if you look at figure 24, that shows that New Zealand has a large number of unit title developments that have a very small number of units in them. So between 1 and 5 lots is over 50%. Only 3% of developments have 50 or more units. However, the units, if you look over at figure 23, the units in these high density developments make up 39% of all units. So there's a real concentration in a small number of developments. And I just want to say thank you to Hazel Easthope, whose research provided those graphs. So it's quite nice to be able to have that out there. Thank you. So unit titles have an important role in our housing system here. So New Zealand has a housing shortage, and a lot of our stock is standalone housing, even in our city fringe suburbs. But you can see that from the figures that this has been changing over the years in more recent developments. The government wants to encourage the continued increase in housing density where that's appropriate. And so that increased density can respond to growth and improve affordability. So a well-functioning Unit Titles Act is really important for people who are already owning and living in unit title properties. And it's also important to support new high-density housing as a viable option for new homeowners or renters. So moving to the Unit Titles Act, we have one piece of legislation. It covers the whole country. The unit plan creates the unit title. So the Act sets out a process for the unit plan to be deposited with Land Information New Zealand. So that's the government agency responsible for land registration. When the plan is deposited, the stratum estate is created for each unit in the development, and the body corporate is also created. The unit owner has ownership rights over their own unit, and they're also a member of the body corporate. And the body corporate makes decisions for the management of the unit title property through democratic decision making. The body corporate has various responsibilities. So some examples are having insurance for the unit title property and organising repairs and maintenance of the common property. If a property has 10 or more units, the body corporate is required to form a body corporate committee to undertake those duties. However, the body corporate can opt out of this requirement through a special resolution, which is where 75% of voters agree. So there are a number of places in the Unit Titles Act where there is this ability to opt out through a special resolution. Some body corporates choose to have a body corporate manager to undertake the day-to-day management of the body corporate, and what a body corporate manager does really depends on the individual contracts between the manager and the body corporate. It varies quite a lot. The body corporate will levy each unit owner to pay for the operating expenses, and a body corporate must have a long-term maintenance plan which lasts 10 years to identifying any upcoming maintenance requirements and costs. The body corporate, again, must also have a fund to meet the requirements of the plan. However, again, this is one area where they can opt out through a special resolution. Now, I'm just going to click to my next slide. There's quite a lot of words on it. This is about information disclosure. So before someone signs an agreement to buy a unit title, the seller must give them a pre-contract disclosure statement. So as you can see from the slide, it contains information such as the levy amount for the unit, the planned maintenance, and the funds held by the body corporate. Once the agreement is signed, but before the sale is completed, there is another disclosure statement. So this statement is really to aid the settlement of the property, and it must include details of any levies due, whether there are proceedings against the body corporate, and any changes to the body corporate operational rules since the previous disclosure. A buyer can also ask for additional information. There's quite a long list there, so a buyer could ask for all or any of that information, and that may come at a cost to the buyer. Now, if there is a dispute about a unit title property, the parties can go to the tenancy tribunal. So despite its name, it also covers unit titles. And that's intended as a quicker and cheaper way to resolve disputes. If the dispute is above a certain threshold or deals with certain matters, then the parties can have to go through the court system. So those are the basic features of the Act. Now I'm going to discuss some of the issues. In 2016, a group of sector leaders presented the government with a report on their concerns with the Act and some possible solutions. So the government undertook a review. There was a public consultation document which set out the options and proposals in 5 main areas. So I would like to acknowledge the 119 submissions in that process. And I'm going to just outline the main proposal areas and then talk about where the review is at now. And I've got a new slide for there. So you've seen how complicated the disclosure process is. So one of the proposals was to amalgamate the disclosure process into one step. And another proposal was to include additional information in the disclosure document, so more things that people thought would be useful. On long-term maintenance plans and funding, so as I said, at the moment, those long-term plans are required to be 10 years, but sometimes that does not cover all the upcoming maintenance. Things don't always fall within a 10-year period. So one of the proposals was to extend that time frame out to 30 years for properties that have 10 or more units within them. So it was also proposed that the plan be signed off by a professional, like a surveyor or an engineer, just to confirm it includes all maintenance, repairs and defects in the building, so it's accurate. So as I noted earlier, the long-term maintenance funds are required, but bodies corporate can opt out. So the proposal was that properties with over 30 units would not be able to opt out of that fund requirement. So moving on to body corporate governance. There were a number of proposals about improving body corporate governance, more than I can get into here. So a couple were that the chair and committee members must declare conflicts of interest and to make clear what that actually means. Another proposal was to set out the duties of the responsibilities of a committee in more detail and to limit the length of service contracts that can be entered into. In particular, sometimes developers can enter into service contracts for quite a long period of time and then lock the body corporate into something that they might want to actually end. Then the issue around body corporate managers. So the duties and responsibilities of body corporate managers are not set out in the Act. Body corporate managers are not regulated by any legislation. So it was proposed, first of all, that the functions should be set out in the Act so people understand what that role can encompass. And another proposal was that the body corporate managers must be a member of a professional body. Another proposal was that the properties with 30 or more units must have a body corporate manager to help those properties meet their obligations. So finally, the discussion document proposed reducing the mediation and tribunal fees for resolving disputes. I was very interested to see the Canadian fees, which are significantly less even than the proposal in 2016. So that was interesting to me. So those are the 5 issues and some of the proposals from those 5 issues. And it's important to note here that the proposals and the discussion document were the original proposals. They're not necessarily what might occur in any future amendment. So the proposals may be different, and that will be based on the submissions received and other advice that the government has. So following this public consultation process, the review was progressing, but then New Zealand had a change of government in 2017. The incoming government decided to focus on other priorities for legislation in the housing space. So that mainly related to quite a few changes in the rental market. So what's next for us? New Zealand just had another election in October. So the government indicated before the election that it would review the Unit Titles Act. So it looks as though this legislation may receive attention over the next few years, and I'm sure this will be welcome to many people in the sector. And that's the end of my presentation. Thank you.
Thank you very much indeed, Susan. Fantastic to get insights from our friends in New Zealand. Very interesting to see where you are, if you like, on the spectrum of change and of progress, if you like, in terms of the regulation and management of your unit title properties. So thank you very much indeed, Susan, for being with us. Moving on to our next speaker, who is with us from relatively close by, and we have with us Dr. Nigel Glenn of the Association of Residential Managing Agents in the UK. Nigel is the Chief Executive Officer of ARMA, and as I say, we're delighted and grateful for Nigel and his time this evening. I think, Nigel, I'm going to bring up your slides. Is that right? Yep.
Yeah, that's right, David. Thanks.
Perfect. So I will just bring them up here, and hopefully everyone can see them okay. And I'm in your hands, as it were, Nigel. So thank you very much. The floor is yours, and give me the
Thank you, David. Slides. Apologies to everybody. I might have a doctorate in science. I might have once been a CEO of a financial technology company, but I can't figure out how to use an iPad. So I'm going to have to be very precious and say to David, can you, next slide, please, David. So I've just got a few slides here. I wanted to give you an overview of what property management in the UK is like. So ARMA, the Association of Residential Managing Agents. So I'm coming from a not-for-profit trade association side, rather than I am a regulator, but it's a self-imposed regulator. So looking at England and Wales, Scotland we have different, Northern Ireland we have different, but in England and Wales we have the dominant model here is leasehold, which is where you actually, when you buy a flat, it's a common misconception, you don't actually buy it, you effectively rent it for a very, very long period of time. To give you an idea of the size, 4.6 million leasehold units, which as Enda pointed out is around about 14% of the population. A lease typically runs 125 plus years and can be extended, but obviously it also runs down, so the remainder is sold. So if I sold my flat now, I've had it for 20 years, technically I'd only have 105 years left, so I'd be selling that part about it. That becomes significant when it gets to 80 years because the banks start getting very interested in mortgages when you have less than 80 years tenure. We may have ground rents payable to a third-party landlord, which has been a bone of quite a lot of contention, and I think that's going to be abolished going forward. The landlord actually, though, may be a third party or maybe a flat owner themselves. So what we do have here is we have an ability for people to buy out or enfranchise their own block, and that is quite common actually. And the other thing with the lease, it contains many restrictions similar to a strata or common hold. So for example, the classic ones are you can't sublet without a license, or you can't permit alterations without a license. And those make sense if you think about it, independent of whatever the ownership structure is, because it's more a reflection of living with other people and how you behave towards each other. Now, compounding that, we have straight freehold, so freehold houses, particularly on estates. We have housing associations where you have the social sector owning or part owning, and you have staircasing. So we have those. We also have common hold. It was introduced in 2002. That's akin to strata. It's not been widely adopted to date. There's a whole bunch of reasons for that and a whole load of debate over that. But I think last I looked, there were 16 common hold buildings with 161 units. So that didn't take off over here. However, our government is committed to promoting self-management, either via reinvigorating common hold, increasing enfranchisement, so where you become the landlord, even though the lease structure stays in place, or the right to manage, which is a different situation where you interject yourself between the landlord, but you don't actually own the block, but it does mean you can appoint the managing agent, determine the budget, etc., etc. So we've had quite a lot of consultations from the Law Commission. And thanks to Hazel, by the way, on this, because I know the Law Commission reached out to her, and I learned a lot from Hazel, also a visit to Brisbane, and fed that back to the Law Commission. And I think they've done a very, very good job at looking at common hold and trying to avoid some of the pitfalls that we witnessed overseas. A problem for us, we believe, is managing agents are unregulated. So we are the sole self-regulatory body. That to me is not very satisfactory, because if I want to come down hard on somebody for breaking the rules, all they have to do is leave armour and they can carry on trading. So there is a proposal called Regulation of Property Agents submitted by Lord Best. The government is still looking at it. They have other issues going on at the moment, namely COVID, Brexit, etc., etc. It only actually covers professional managing agents, which I believe is a hole in that. So we have a considerable number of leaseholders, millions, who actually are under self-management and will be excluded from the benefits of that, but that's a separate issue. Looking at the build-to-rent sector, there's also quite a lot of private equity investment into managing agents and the fledgling build-to-rent sector, which is starting to burgeon over here. It's still relatively small at the moment, but if you look at the rate of change, that's going to become much more important. David, if I may be precious, thank you. So looking now at the models that we have over here to manage, the lease is everything. So whenever somebody has a question and they ask a solicitor about, can this happen or can they do this? The first question is always, what does your lease say? So it determines what you pay for, what the relationship is, how much you pay for it, etc. Now, to make life miserable for all of us managing agents, nearly every building has a different lease. And I hate to say this, if the solicitor is on here, sometimes it's a miracle if the percentages add up to 100%. So that really is a pain for us to try and get through, because you have to understand every single building, and they might be different in the same development. You have to understand the nuances of each of the lease. The lease itself will dictate what works can be collected against. So it very specifically says who owns where, the demise, where does the window, is it the occupant's problem or the outside, the communal problem? So again, that will vary. A key thing there is from leasehold maintenance versus improvement. So the whole point of leasehold law is to protect leaseholders from a third-party landlord, if you like, gold plating and marbling the block at the leaseholder's expense. So you can't do an improvement. So this does become a problem when you have the leaseholders have clubbed together and bought out their own freehold, because they are still bound by that rule. So what you could argue is the maintenance of that block is on the percentage in the lease typically. And then if you want to make an improvement, such as adding cabling for fast speed transmission broadband, that is an improvement. So you wouldn't be able to do it. You'd have to go back to the shareholders and ask them to contribute. So it just makes it a bit of a tricky one to go there. A big issue, again, unless the lease says you can have a reserve fund, you actually can't collect it. And some managing agents have fallen foul of this, where they've, with the best intention, have started putting a reserve fund together for, you know, lifts and roofs and so forth. And then all it takes is one leaseholder to say, I don't want to pay towards that, and you can't force me to, and the whole thing collapses and the money has to be given back. Another thing to look at is a test of reasonableness. So this is a protection. It's called Section 20. So if any one single leaseholder in a block is going to be charged more than £250, then you have to go through a Section 20 process, which is two successive processes of 30 days, then another 30 days after, can take up to 90 days. That £250 was set in 2003 and hasn't moved since then, and VAT has changed. So there is a push to get that brought up to date, simply because a lot of time and money is spent on admin. Now, many blocks do self-manage. So we have under ARMA 1.4 million, about 5% of the UK population. Of the ones that we know, 60% of those are leaseholder-led. So the leaseholders do have quite a lot of say. Service charge levels are the same. We did a study on this to see if a third-party landlord, independent landlord, was managing the service charges, or if the RTM or leaseholders themselves, and it came out almost to the penny exactly the same, which is kind of what you'd expect, actually. An issue we do face at the moment is recruiting directors, whether that's generational, that younger people now just don't want to give up their evenings and aren't interested. We don't know. It is likely to get harder because one of the consequences of Grenfell and the legislation that's going to be coming out of that is making directors personally accountable. So it will be much harder to get people. I mean, I wouldn't volunteer to be a director. There are ways around that, of course. So we can propose that perhaps the lease be adapted to allow third-party directors to be who are insured and are prepared to take that job on. We're talking about that. At the moment, there are no obligations on directors retraining. So as typically happens, you're having a glass of wine with somebody, it's Nigel, why don't you join the board? So you join the board and you don't actually realize the legislation surrounding being a director of a UK company, let alone property law. So that is also an issue which is being looked at. David? So one of the questions we were asked is what difference did COVID-19 make to us? And like everybody on this call, obviously phenomenal. From a personal point of view, ARMA, as a trade association, we realigned ourselves as a single source of information for managing agents. You know, we were swamped with managing agents ringing up saying, what do I do? A typical thing would be my clients want to go hold an AGM and they're demanding I go. It's very difficult for a managing agent to argue with that. But if they say, well, our governing body dictates that we shouldn't go, it depersonalizes it. A big thing we did was try and provide the cool, calm, collective view of what the legislation was. So our government, like I'm sure everybody's government, was making things up on the hoof. And so we would collect all of that, fill in the gaps, try to put the property management slight on it. So there were 13 versions of that within the first 3 months. We shared that with anybody. We shared that with other associations. And we hope that was particularly valuable. Another thing we looked at was coming out of lockdown. So when your staff have to go back to sites, let alone your own office, what is the best practice there? So we had a team of experts looking at that. Now, Tom will be coming on fairly shortly from the US, but we had weekly calls with the US, Australia, so the association out in Australia, Spain and Scotland, and the UK Apartments Association, which is the build to rent. We were sharing best practice, just talking to each other, reassuring each other. I have to admit, Tom, when you come on, you might have found it the same. It was very hard to go to sleep after, you know, at 9 o'clock at night, listening to what was happening to Pepe in Spain, because they were about 2 weeks ahead of us with what COVID was affecting on them. But that was very, very useful. We all got to know each other very, very well, and we shared lots of resources. So that was a very positive point of view. On our own point of view, we would then meet with government every 2 weeks to discuss the sector. Something which came out of the discussions again, particularly with Tom, was where people weren't paying their service charges, which over in the UK would be disastrous. We'd say we could have 5 to 6% of the population decanting because cleaning wasn't being done or security wasn't there. So constant monitoring of that with our friends in the BTR sector, but also our own members, and getting Britain back to work, looking at how much maintenance work was being conducted compared to previous years. A couple of other things we did, weekly webinars with members. So I would speak for about an hour to talk to them about what was happening around the world, what was happening in our sector in property and in property management, feeding back what I'd learned from our colleagues overseas and our colleagues in the build to rent sector over here. So that was very, very popular, and we've continued those to this day, not weekly anymore. And we would feed it again back from the polls and that back to government. So that was very popular. And then the final thing which we had to do was learn how to go online. So all our things in the past, regional briefings, conferences, training, etc., were face-to-face, and we had to figure out how to move that online, which is a mammoth task, but has gone extremely well, so much so that we will probably continue with hybrid models in the future with, you know, attendees who want to attend on conference, doing so in person, but the staff back at base might not be able to afford to go away for a whole day. We could then stream it live to them as well. So finally, I think this is my last slide on construction. So we were unfortunate enough to have Grenfell in our midst. Massive consequences. It's pretty much all I do nowadays is cladding related. A very significant thing here, we had Dame Judith Hackett look at our construction mechanism, and a big thing really is to realize about future versus legacy stock. So it's all very well putting in things about, you know, the golden thread going forward. You should have this, you should know what the construction diagrams for the building, fantastic. But when we look at stuff that's already been built, it is in a poor state and we actually have no records. So that really is a big issue we're facing. With leasehold, building owners are obliged to make buildings safe, and the government has been sort of hanging on about that, saying that the building owners should pay because they are obliged to make buildings safe. But actually, the way leasehold law works, it's leaseholders who are facing the costs, and have been for many years now, and it's a terrible situation they face. I could expand on that for hours, but we won't go for that one. The UK government has in the end committed £1.6 billion to replace non-ACM and for other materials. That is a drop in the ocean as far as we can make out if you look at what else is involved there. It's also excluding buildings under 18 metres, so pretty tough if you're in 17 metres and are facing, you know, potentially life-changing sums being demanded of you of tens and tens of thousands of pounds. Other issues are also not covered, so this comes down to, again, construction, fire breaks, compartmentation. These are excluded from funding, and this is something we've learned from Grenfell. Now we've started looking and frankly knocking holes in buildings, which we didn't do before. We are finding that they just haven't been built terribly well, or actually well at all, and that is a huge issue, and leaseholders are again just being left with that to foot the bill, because quite often developers have done special purpose vehicles which have collapsed, or the developer themselves have collapsed, so there's nobody else to hold accountable for those funds. Waking watch, buildings insurance premiums, again proving very costly. This is significant again for going forward, because when we're looking at reserve funds, those buildings that had them, those are pretty well drained now. So when the roof collapses or leaks in 5 years' time, there's going to be no money left because of these issues that they have to be paid for. In a survey, the average waking watch was £330 per month per unit, which is an enormous sum of money for a lot of people. So the biggest problem we have here is funding works. As a trade association, our stance is that only really government can do this at the moment, that they should fund it. Let's get people safe first and foremost, and then we can argue later about who should and who can pay, and government can work that out. You know, if we wait until we've actually ironed through all of that, we'll still be here in 10 years' time where people can't sleep because they're in unsafe buildings, the mental stress, they can't sell, they can't rent, they can't move jobs, they can't divorce, etc., etc. A couple of final points, something which isn't really being looked at, and we are really asking our government to look at, is the industry capacity to remediate. So I was in front of a housing select committee and said, if you gave me 50 billion tomorrow, it's still going to take 5 to 10 years to work our way through this, because there's only so many cladders and scaffolders who can do it. So, you know, the question there is, what do we do in the meantime for people who might, you know, you might be successful, get allocated funds, but it might be 3 years before we can actually get around to you. So that's where we're at, and there's a lot of fire safety and building safety legislation going through Parliament. So an extremely busy time here in England and Wales. Thank you, David.
Nigel, thank you very much for your contribution. Some sobering thoughts in conclusion in your own slides and your own session. So thank you very much. We'll perhaps touch on those in the Q&A. I am conscious of time, so we are running slightly over time, but we'll hand over without much further ado to our final contributor, who is Tom SCIBA, and Tom is the Chief Executive Officer of the Community Associations Institute in the US. We're very grateful to Tom for his time, and given the time constraints, I'll hand straight over to Tom. Tom, the floor is yours. Thank you.
All right, thank you, David. And I will try to be quick here. The good news is you've heard already many of the challenges that are going on in the world are exactly the same as they are in the United States. And in fact, I've been lucky enough to be invited to come and speak and meet on issues related to community housing in actually all the countries that are represented today, with the exception of Ireland. That's a hint, David, that maybe someday we'll get a chance to do that. But
vaccine permitting, hopefully, Tom. Thank you.
Absolutely. I never thought I would say I missed getting on airplanes, but I actually miss getting on an airplane. So none of this is will be terribly surprising to you. The difference is scale. The two differences in the US. One is scale, and the other is, unfortunately, fragmentation. And so we'll talk about both of those. We have about the same number of communities in the US as Australia does. The difference is we have, our average community is about 100 units, 100 lots. And in Australia, it's closer to 10. So we have about 27 million housing units. About 23% of the US population, almost 75 million people, live in some form of community housing. About half of that is vertical housing, condominium or strata. The other half of it is horizontal, what we call homeowners associations here in the US. The range of sizes, and I think Susan put up a chart that looked at, how many schemes they had with 1 or 2 units, or 4 up to 5 or up to 10. The range in the US is also much more variable. We have very small, 2 and 3 and 4 unit stratas in urban areas. We have communities in the United States that have 22 to 25,000 homes in a single master community. So this, again, the scale is just a little bit different. It's a big chunk of our economy. More than 6 trillion in property values, about $90 billion US in levies each year to support annual operations, and about 25 billion in sinking fund reserve funds. Right now, today, 80% of new housing in the United States is in some form of community association. Now, just to give you a little historical perspective, there have been community association housing properties in the United States for almost 150 years, but it really didn't jumpstart and take off until the early 1970s. So in 1973, there were about 10,000 associations across the United States. We're now at 360,000 associations, and the vast bulk of new housing of any kind is being built in those associations. Professional management, as you think about the larger and more complex communities, is become absolutely mandatory. Somewhere around 60,000 professional community managers who make the entirety of their living from managing communities. We have licensing, but like most everything else in the US, it's fragmented. We have 10 states in the United States that have some form of licensing regime for professional managers, and the other 40 states plus territories have none. And then we obviously have a lot of business partners. Because of the size of the scale of the industry, we have a huge number of business partners who actually specialize in this. So we have solicitors who do nothing but community association law. We have accountants who do nothing but community association accounting. We have a whole cadre of service professionals that really serve this market because it is so large. The big advantage, of course, there is that we have folks who really understand the industry, understand the needs of owners, understand the needs of the owners' corporations. But like I said, all the challenges are exactly the same. And I put this slide up both to talk about where the communities are, and as you can imagine, Florida, California, The Northwest are some of the places which have large number of communities, but you can see the growth rate on the bottom. But I wanted to put this up really to talk about fragmentation. So Ireland has a single set of laws governing associations. Nigel has to deal with a set of laws around the UK. The same is true in New Zealand. Australia has state laws. We have 55 different sets of laws, 50 states and 5 territories. Everyone does it completely differently. And I will tell you, those laws range from essentially nothing, where essentially it's just a Corporations Act that governs an association. So there's no specialty law in some states, to the state of California, where the law that governs how you operate a community association is more than 1,800 pages long. It is literally feet of shelf space. And to give you one little example, if you're going to run an election for the Owners Corporation Board of Directors in an association in California, in addition to being required to hire an outside elections administrator, there is a 43-page law you must comply with to ensure that the election is considered valid by the courts when someone challenges it. As you imagine, this is a nightmare for us, and we spend an enormous amount of time doing legislative things and trying to get reasonable legislation passed around the country. But it is a big challenge for us as an organization. But here's where the fragmentation comes into play. I spend obviously an enormous amount of time in Florida and California and New York and other places like that have extensive legal regimes. And I spend very little time in Montana and Oklahoma and Nebraska because there isn't much to work with there. There's not much law governing associations, but there aren't that many in the first place. So I hate to say there's a upside to a pandemic, because there's really no upside. We all have too many friends and family who've suffered as a result of this, personally, medically, economically, every other way. But things have happened, and some of the other presenters touched on this, that have forced us to adapt the way we do business, the way associations are managed, the way managers operate, the way boards act, the way AGMs are held. All these things we've done under emergency orders. So the last month or so, we're getting prepared. Most of our states come back into legislative session in late January or early February. We're trying to make the argument to many of these state legislators that the emergency actions that they've allowed over the last 10 months are actually things that are beneficial and that should be put into, enshrined in the law permanently to allow us, for example, to have electronic meetings of the board and electronic AGMs to make it accessible to more people. We've found that, in fact, attendance at AGMs has gone up via Zoom and to a much higher level than it ever was when it was required to be in person, or limited only to be in person. So there's a whole series of these things that we're trying to build a legislative agenda now to what will transform the industry over the next 10 years. And we believe some of these will pass, some of them won't pass. Some states will be more progressive than others, obviously, and we'll go on. The other thing I wanted to mention before we move on, and I know, David, we're tight for time, is we have put together an enormous number of resources related to responses to COVID. And as Nigel knows, because we've shared a number of these things, we've made, even though we are a membership organization and most of our material is only available to members, all of the COVID materials are actually available free on our website. So if anybody who's on the webinar today is interested in looking through some of those materials, there are recorded webinars, there's FAQs, there's printed material, there's a whole variety of things. Please feel free to log on to our website and dig into our coronavirus page and help yourselves. If you want to file the serial numbers off and use it in your country or in your communities, you have my blanket permission to do so. So, David, I'll turn it back to you.
Tom, thank you very much for your generosity and for your indulgence as the last but by no means the least speaker in our session. Thank you very much for your contribution. And as you say, there are no upsides to a pandemic. That said, I suspect we would not be engaged in this particular forum online tonight were it not for the situation that presented itself. So let us say that we'll take that as one minor plus. Look, we have maybe 10 minutes with the panelists' indulgence. I'm conscious that some of our panelists are starting their working day and others are very much concluding theirs. We might take 10 minutes for questions, and this might almost be a rapid fire round, if you like. I don't intend to go to every panelist with every question, but perhaps I might lead off with Hazel. One of the questions, Hazel, that came in was, I would be interested to hear if the panel thinks the pandemic experience in cities will see a drift away from high density urban environments. So Hazel, I might throw you in on that briefly, please.
My personal opinion is no. At least in the Australian case, what we've found is that the pandemic has meant that a lot more people are living at home and are appreciating their local walkable environments. And higher density environments are often more walkable and are much closer to the services and facilities that people need. So I think in the Australian context, I don't think that it will see a move away from higher density areas. Although having said that, we are seeing a bit of a move, a tree change and sea change move of people who found that they are able to work from home permanently or more often and are moving to more affordable housing in areas outside of the cities. But I think apartments will remain popular because of their proximity to services.
Thank you very much. Thank you very much for that, Hazel. I'll move on to a sort of a regulatory question that came into us, and it was as follows. I would find it very interesting to know the various global perspectives on the levels of assurance required for accounts and reserve sinking funds of owners, management companies, or condo associations, or bodies corporate. Are the financial accounts required to be audited in accordance with auditing standards, or is there some other level of assurance expected by A regulators, B members? Just from an Irish point of view, most owners management companies take the form of what's called a company limited by guarantee, and they are exempt from having a statutory audit unless one of the members demands or requisitions one, if you like. So Robin, I might ask you perhaps on that, on the audit on the assurance side, for your quick perspective on that, please.
Yeah, thank you. Yes, in Ontario, under the Condo Act, all of the corporations are required to have annual audited financial statements. And as part of that, which is obviously looking at the health of the organization and the expenditure and revenues of the past year, is look at the reserve fund and whether or not the information provided in that reserve fund is sufficient. As well, I guess at the creation of a condo corporation, they're required within 1 year to establish a reserve fund for a 30-year horizon. And thereafter, there's every 3-year minimum review of that reserve fund to see if it's adequate in terms of making sure the common elements are maintained over that period. And that's an area that is continually discussed and is being looked at further at this time in Ontario, similar to other jurisdictions. Thanks.
Thanks, Robin. I might ask maybe Susan to comment on that from a New Zealand perspective. What are the audit requirements for your unit title companies?
Sure. So in terms of the bank accounts held, there is a requirement to either have them audited by an independent auditor or reviewed by an accountant. However, this is one of those provisions that the body corporate can choose to opt out of through a special resolution. They can't do a blanket opt-out, they have to do it sort of per year. So they might say this year we don't think we need to, and that may apply best to the smaller companies where there may not be a lot of money in the account or much happening. Yeah.
Perfect. Thank you for that, Susan. It's interesting to see the different treatments, and if we had more time, we could go around to everybody. But we might move on to some of the questions that have come in live, and certainly Andrew Byrne makes an observation that he has participated in 3 annual general meetings over the last 2 months, and they've been better attended as Zoom meetings than they previously were as face-to-face meetings. And I think Tom has touched on that, and I imagine that's the experience. Enda, you might like to come in on that. I think you mentioned that in your presentation in terms of engagement.
Yeah, I think, look, in Ireland, the situation was there was an emergency changes made to the Company Act, which facilitated this approach, and it's definitely been a huge benefit. It allows people to engage, I suppose, and you definitely get bigger attendances. I suppose the one thing I will say, it is best suited probably to more routine and mundane matters. The issue of building defects was something that's been covered by a number of the speakers during the course tonight. And when you get into dealing with those sort of issues and the kind of robust discussion that's required in explaining what's going on and getting to a point maybe where you have to do a levy, there's nothing beats that whole in presence discussion, because you need to have that sort of robust debate. That is the one difficulty we find with Zoom, is that mundane formal matters are good, but the whole debate and discussion is a bit stilted. But I'll see if there's any other opinions,
Super. Thanks, Enda. A left field one, if you like, on the future agenda. How is, and I might maybe line this up to Nigel, perhaps, how is sustainability and carbon neutrality, perhaps, in buildings going to be promoted and rewarded for the forward-thinking developers and builders?
Yeah, that's an interesting one. Our government is definitely very pro getting to zero net emissions. We've made some very public statements about that. The developers themselves, they'd have to be incentivized to put that in, because once they're built, frankly, they don't care how, in a sense, how efficient the building is unless it's secured them a higher value at source. The problem again with leasehold is you can't do the improvements. So you can't go to everybody and say, tell you what, let's put double glazing in everywhere, because that would be defined as an improvement. So we have a bit of a balancing act there. So it would really require the government to mandate that for the developers and builders to do that. And we saw that, we've seen that in the past with things like the green deals and so forth, which ironically led to Grenfell style cladding, but that's a separate issue.
Thank you, Nigel. A question that has come in from Bernie Wales. For those who've already regulated corporate bodies and regulated property professionals, what's the #1 lesson you've learned which would be useful for the UK government to take on board when introducing regulation to the UK? So maybe Hazel, that might be a sort of a cross-border one that I could ask you, perhaps.
Sure. So we have regulated strata managers in some states, but not in others. I would say do it is the biggest lesson. It does make a difference to have regulation, because the regulation is tied to qualifications and to continuing professional development. So I do see that we see very high performance amongst, or better performance amongst managers in states where it's regulated.
Thanks.
If I can add to that, David, well, it increases accountability, and that's where communities typically have fallen down, is whose responsibility is it to do a particular thing? What's the accountability structure in place? And having some kind of regulatory structure for managers, mandatory education, mandatory ethics, mandatory continuing professional development, all the things that every other profession, you mentioned you're an accountant by trade, attorneys, accountants, insurance, all have that as part of their professional architecture of their profession, and that's what we have to have in our industry too.
Thank you, Tom. I think we have lost our New Zealand contributor, Susan, which there's a certain irony in her departure. She's had a fire alarm in her office, so I hope it's a test and it's good for compliance. So nothing like irony to keep us on side. Perhaps a last question on the future and the green agenda. What are other countries doing to future-proof their management companies in relation to, say, electric cars, solar panels, and so on? So I might throw that to Nigel. Perhaps you mentioned some of that in your session.
Yeah, well, again, it's a bit tricky for us, because we have this, particularly under leasehold, this division between the improvement and the maintenance. So electric cars, for example, is a very thorny subject. People want to have electric charging points, but there can be considerable costs involved. So everybody, well, when I talk to people about it, they go, oh, that's just easy, isn't it? You stick a charging point in. They forget they then have to look at the capacity of the wires actually coming into the block. Can it take, 50 cars simultaneously trying to charge up, a 100 amp hour battery? So it's something which we would like to do, and our government is very keen for people to do. But personally speaking, for us in England and Wales, the problem will be the lease would probably prohibit that. So they'd have to look at a different way of doing it.
Okay, thank you on that one. Look, we're coming up to past 10 minutes past our time. I'll go around perhaps to each of our speakers, and unfortunately, as I say, we've lost Susan, but I'll go around to each of our speakers in the order in which they presented for a last maybe observation or takeaway on insights and learnings, and maybe to Hazel first, if that's okay.
Sure. One thing that's on my mind at the moment is what the longer term impacts on the property market is going to be of COVID-19. Not only because of people's incomes being affected, but also because of changes in people's preferences for where they want to live, and changes in the demographics of cities. So for example, in Sydney, the projections that I've seen see the city continuing to grow, but to age. So at the moment, we're dominated by younger adults, and the projections show us being dominated by older adults. So will that mean that people are looking for different things in their apartment buildings? Will we have more owner occupiers? Those kinds of issues are things to watch, I think. Oh, you're on mute, David.
Thank you very much, Hazel. Thanks indeed for that. And hopefully, when you do your next edition of your book, you'll include Ireland and you'll come to visit us. So we look forward to that when time permits. Robin, maybe a last comment from yourself, please.
Sure. Thank you. First of all, thanks for hosting this, David. It's been a very informative event, and I think the takeaway for me is the emerging issues that are common among all of us, and there are some differences, which for me kind of I ask myself what do those differences, are they emerging, and I just haven't been made aware of them yet. So the different structures were interesting today, different regulatory models, and I think we can all learn from that, and to the betterment of those who live in strata or apartments. So lots of takeaways. Thank you.
Super. Thank you, Robin. We'd echo that. And over to Enda briefly. Thank you.
Thanks, David. Yeah, I think, look, as many of the others have commented, COVID is going to have an impact. I think the ability of owner-manager companies that they are here and companies broadly to collect the funds required to fund not alone the operation side of the house, because the last time we saw this in 2008, 2011, 12, the tendency is would badly advise boards of directors to cut costs, and those costs then come back to haunt people 5, 6, 7 years later from a maintenance perspective. So I suppose it's the financial well-being leading to the long-term maintenance issues in buildings. That's I suppose the biggest issue.
Super. Thanks, Enda. Quickly over to Nigel, please.
Mine is I'm afraid, a bit of a gloomy one, which is I think we still haven't really figured out how bad the situation is going to be with the quality of build that we have in our legacy stock. I think this is going to be with us for a long, long time, and it fouls up the rental market, the sales market, everything. And the socio-economic impact, I think we still haven't figured it out yet, and that's still yet to come.
Thank you, Nigel, and over to Tom, please, for Tom's closing remarks.
I definitely have to agree with Nigel. The existing built environment is going to drive a lot of the challenges. But what I've discovered in traveling around the world now for the last 18 years for CAI is that the vast majority of issues, the vast majority of challenges are exactly the same everywhere you go. We call them different things. There's obviously always local nuance and local law and regulatory differences, but the issues that arise from people living together in close proximity are almost always driven by the people and not the building and not the law, and the biggest challenges that managers face, that owners corporation boards face are built around people living together in close proximity.
Thank you very much, Tom. I think phrase, a takeaway I might have from that myself is our shared humanity. If we've learned something from the COVID situation, it's our shared humanity and the challenges we face in that respect, and that can be applied in the context of multi-unit and apartment sector living as well. Look, we'll wrap it up there. I think it's nice to wrap it up with Tom's festive background. Certainly appreciate the colour, Tom. Thank you to all our contributors, to Hazel, to Robin, to Enda, to Susan. Thank you for Susan for being with us, to Nigel, and indeed to Tom. We're very grateful for your time in organising and contributing to this session, and thanks indeed to your colleagues who are in support roles. Thanks also to my own colleagues, to Sarah and Tara, who kept me on the straight and narrow in terms of our session here tonight, and to my other colleagues, including Michael, Michaela, and others who were very helpful in putting our session together. We will share the slides of that our contributors very generously have pulled together. We will share a link to the recording, and we will circulate that in the coming days. So look, it remains for me to say thank you very much for coming on and tuning in to us tonight. We hope you found the session insightful and took some lessons away, and some, if you like, shared learnings. Grateful for you for being with us. We'll say good night, as we say in Irish. Fan slán, stay safe, and enjoy the holiday break. Thank you all indeed. Good night.